Hello and welcome to this webinar to discuss the EU proposed directive on corporate sustainability due diligence and what it means for actors outside of the European Union. My name is Eline Vronsky. I'm the head of the Human Rights and Business department here at the Danish Institute for Human Rights, which is Denmark's national human rights institution with an international mandate to also promote human rights internationally. When it comes to mandatory human rights due diligence, the Institute has been conducting analysis and is trying to mobilize the NHRI community to engage with the topic. This directive, when adopted, will require larger companies headquartered in the EU or non-EU companies with large operations in the EU to conduct human rights and environmental due diligence across their global supply chains and value chains. At the moment, it is estimated that 12,000 European companies and 4,000 non-European companies would fall under the scope of the proposal. We were happy to see that so many of you were interested in joining us to understand how this proposed legislation will affect non-EU stakeholders and how they can be heard on the design of the actual legislation. And indeed, it is an important stepping stone towards enhanced respect for human rights by businesses in their global operations. It's been a long journey to get to this stage with a concrete proposal on the table. It is the result of the hard work of many human rights defenders and advocates worldwide who have for decades denounced the gaps in the protection of human rights in the context of transnational business activities and the lack of accountability of corporate actors, in particular when abuses occur outside of their home states. Advocates have pushed for the clarification of how international human rights standards apply in a business context. This led to the adoption of the UN Guiding Principles on Business and Human Rights back in 2011. But since then, we have seen a steady incorporation of this soft law standard into a range of frameworks, increasingly encouraging companies to conduct human rights due diligence. More recently, we are witnessing an increasing legalization of the corporate responsibility to respect through the adoption of domestic legislation. And now we have this EU proposal, which would entail that the 27 EU member states will require, through law, large businesses to conduct human rights and environmental due diligence and potentially hold them accountable if they fail to do so. However, as we will hear, devil is in the details, and to have an efficient piece of legislation that will be effective in addressing negative impacts of businesses, we need to look at the implication of certain design features that are currently on the table. First, I will ask my colleague Gabrielle Holly, Senior Advisor on Business and Human Rights, to introduce the content of the proposed directive and highlight what the main issues are and why and how non-EU stakeholders should care and get involved. After that, we will get a brief overview by Tabitha Bailey from the Global Reporting Initiative on the developments related to the Corporate Sustainability Reporting Directive that, as you will hear, is intimately related to the mandatory due diligence proposal. Then I hope we will have about 20 minutes for exchanges. Please post your questions in the chat. You can also raise your hand and we will try to take as many questions and reflections as possible. But of course, this conversation is only the start and we hope that it will continue potentially offline. Please note that this webinar is being recorded and we'll be sharing the recording with registered participants. Many thanks. So over to you, Gabrielle.
We'll then touch on what the CSDD means for non-EU actors. And as I've listed here, there are a few particular touch points that we'll be discussing that I think all of you should be aware of. Firstly, it will directly apply to certain classes of non-EU companies. It has a requirement to conduct due diligence across the value chain and that will therefore extend beyond the EU. There are also requirements for companies to set up complaint mechanisms and for state supervisory authorities to hear substantiated concerns about the conduct of due diligence. And those will be open not only to EU stakeholders, but also to non-EU stakeholders. Then we'll touch on the civil liability mechanism. And then lastly, we'll note that this is a potential inspiration for other national legal systems and advocates in those contexts who are hoping to push for mandatory human rights due diligence laws in those contexts. Now, we have quite a broad range of stakeholders joining us today from the business community, from civil society, NGOs, national human rights institutions, policymakers, international organisations, and we welcome you all. And given that we have quite a broad range of stakeholders, we'll aim to make sure that the picture we're presenting is relevant to all of you. So firstly, to briefly touch on the EU regulatory landscape as a whole. So as I mentioned, there is quite a lot going on. In recent years, the European Union has introduced a range of regulatory initiatives which in different ways seek to address the impacts that businesses have on the enjoyment of human rights. And we've highlighted a couple here and separated them into three buckets. Firstly, company-focused initiatives, so real economy companies, the Corporate Sustainability Due Diligence Directive, which we'll be discussing today, and its related Corporate Sustainability Reporting Directive that Tabitha Bailey will be speaking to in a moment. Secondly, there are a number of finance-focused initiatives. The Sustainable Finance Disclosure Regulation, which, as it says, imposes disclosure obligations on financial undertakings, as well as efforts to develop green and social taxonomies. And then lastly, the last bucket here are trade and import controls. So we have had a few measures in place for a number of years, like the timber regulation and conflict minerals regulation, which do include a variation of a due diligence obligation. But there are also some more recent initiatives, such as initiatives to address deforestation and forced labor issues, which also are likely to include due diligence obligations. So each of these pieces kind of contributes a different piece of the puzzle. They're all aiming to ensure that businesses and financial institutions and the broader economy as a whole develop responsibly and contribute to sustainable development. But they attack this problem from slightly different angles. So some impose due diligence obligations, which require that companies establish policies and processes which would enable them to identify and address the impacts they have on people and planet. And that includes the Corporate Sustainability Due Diligence Directive we'll be discussing today. Other initiatives address the inner workings of the company in other ways, clarifying requirements with respect to corporate governance of human rights and environmental impacts, as well as obligations to include sustainability considerations and stakeholder impacts into broader corporate strategy. There are some components of the Corporate Sustainability Due Diligence Directive which do include these corporate governance aspects. Others, such as the reporting measures, the Sustainable Finance Disclosure Regulation, and the Corporate Sustainability Reporting Directive, aim to encourage sustainable behaviour through disclosure regimes, requiring companies to report on their impacts and their policies and procedures for managing those impacts. Others, like efforts to build green and social taxonomies, would provide granular substantive direction in terms of what economic activities contribute to environmental or social objectives, as an attempt to address green and social washing. And then lastly, a number of measures leverage EU market access to encourage corporate actors to address their human rights impacts. And we see examples of that in the conflict minerals regulation, the timber regulation, and the Corporate Sustainability Due Diligence Directive, which we'll be discussing today. So it's a very complicated regulatory environment, and there's a clear need for alignment between these measures. In particular, the reforms that are currently being considered in the form of the Corporate Sustainability Due Diligence Directive and the broader regulatory ecosystem. We put out a recent publication that we've included in the slide, How Do the Pieces Fit in the Puzzle, as an attempt to help users make sense of this very complicated regulatory environment. And there's a link to that resource later in the slides. To the main game for today. So the Corporate Sustainability Due Diligence Directive. Now, it's a mandatory human rights and environmental due diligence law, which does include some corporate governance aspects. The EU published its proposal for this law in February this year. It's worth noting as well, for those not completely familiar with EU legislative processes, that this will be a directive, meaning that it's not a directly applicable law, but rather a law which sets out the elements that member states are required to transpose into their own national laws. So this gives some discretion to the member states as to how they satisfy the requirements in the directive, acknowledging differences between the various legal systems. So it is likely that we may see some differences in how the various member states have approached implementing this law in their national legal systems. So as I say, the proposal was published in February this year and will now go through a full legislative process. So there'll be debates among the two legislative bodies of the EU, the Parliament and the Council. And then if it's finally, if a decision is taken to go forward, it will then be transposed into national law. There is a public consultation open at the moment on the proposal, which anyone can contribute to, and we have a link to that, and we'll discuss that in a moment at the conclusion of the presentation. In terms of business and human rights standards, the proposal does generally align with the process of human rights due diligence in the UNGPs and OECD guidelines, but there are some critical departures, which we will discuss in a moment. In terms of the due diligence obligation, large companies and medium high impact companies, both EU and non-EU, are required to undertake due diligence on a range of human rights and environmental impacts on their own operations, on their subsidiaries, and those with whom they have established business relationships in the value chain. More on that very critical concept in a second. So in terms of the due diligence requirements themselves, so essentially what this requires is that companies put in place a due diligence policy, including a code of conduct that will be applicable to their own operations, but also used in their relationships with their contract counterparties. They're required to take appropriate measures to identify actual or potential impacts. They're required to take appropriate measures to prevent or mitigate the impacts that can or should have been identified through that identification process. They're also required to establish a complaints procedure, to monitor the effectiveness of the actions they take to address impacts, and communicate on how they're conducting due diligence. And for those familiar with the UNGPs and OECD guidelines, we'll see that these steps are largely familiar. They broadly do mirror the process of human rights due diligence as we understand it from those frameworks. But again, as we'll note in a moment, there are some quite critical departures from those processes. In terms of what actions a company should be taking to address actual or potential impacts, the directive sets out a menu of options with a lot of discretion given to companies as to how and whether they implement those options. This includes requirements to engage with SME partners, engage in collective action, investing in management or production processes. But there's also a heavy reliance on the use of contractual compliance with codes of conduct and verification. More on that in a second. So to give you a quick account of the key elements here, this has been a highly politicized file at the EU level. It's been the subject of really quite aggressive and persistent lobbying, and it's been, frankly, quite secretive. So for those of us who've been working on this for some years, even we weren't quite sure what to expect when the measure came. So we were quite pleasantly surprised to see that the proposal does retain a very high level of ambition, but there are some concerning aspects, which I'll run through now. So firstly, personal scope. So the directive applies to large EU and non-EU companies. So that's companies with over 500 employees and a turnover of over 150 million euro. And then after a 2-year period, it will also apply to medium-sized companies in high-impact sectors. That's again, both EU and non-EU. So size-wise, that means turnover of 40 million euro and over 250 employees. High impact here is defined by reference to sectors where the OECD has published due diligence guidance. So for the purpose of the directive, that's essentially textile, agriculture, and extractives. Now, SMEs are specifically excluded from the scope of the directive, and the more limited personal scope is an indication of the underlying logic of the proposal. So i.e. that it imposes obligations on larger companies in the hope that they will carry along their SME partners through their business relationships. There's a big emphasis on the need to support SMEs, and it's not completely clear that the right incentives have been struck here. Secondly, the value chain. So the due diligence obligation extends across the whole of the global value chain, and the proposal explicitly acknowledges that businesses need to have regard to their downstream impacts when conducting due diligence, and not simply look to their supply chain. And this is a really important acknowledgement because there are some sectors where the more severe human rights impacts are more likely to occur in the downstream with the end user products. For example, the tech sector, I think that's a clear one. Now, this means because it applies to the global value chain, that its impact will stretch outside of the EU, and more on that in a moment. But there is an important limitation on the scope of due diligence in the form of this concept of established business relationship. So by limiting due diligence to own operations, subsidiaries, and established business relationships, there's an important limitation placed on the scope of due diligence. So an established business relationship under the proposal means a direct or indirect business relationship, which is or is expected to be lasting in view of its intensity or duration, and which does not represent a negligible or merely ancillary part of the value chain. Now that is a bit of a mouthful and quite ambiguous. There are a number of elements in there that could be quite contested, and it's not completely clear how companies are supposed to interpret this. There are kind of indications in the explanatory memorandum and the recitals to the directive, which suggest that this should be interpreted quite broadly. But then the language of the article itself is potentially quite narrow. So there's a lot of ambiguity around this. And it's also a departure from the UN Guiding Principles approach. So this places a limitation on the scope of due diligence based on the proximity of a business relationship, rather than the connection of a business to an impact and its severity. And this is out of step with the UNGPs and OECD guidelines. And I think that it's an attempt, we think, by the Commission to introduce an element of legal certainty here, but it has in turn created ever more ambiguity. Next, contract. So the directive envisages that contractual assurances will be key to the discharge of due diligence, specifically by securing contractual compliance with the provisions of a code of conduct, setting out responsible business conduct standards as a means of taking action to prevent, mitigate, or cease actual or potential impacts. Companies using this contractual verification mechanism will also be required to verify compliance with the provisions of the code. And this can be done by relying on third-party verification or assurance firms. Now, I noted in the last slide that this is one of the menu of options that the companies have to engage in due diligence and address their actual or potential impacts. But on initial review, the heavy reliance on code of conduct and certification carries with it the danger of checkbox compliance. The Commission is intending to create its own model clauses that companies can use. So there is a possibility that company will simply insert model clauses into a contract and then farm out monitoring of compliance to a third-party verification firm, rather than meaningfully engage with the process of due diligence. I think that we're all aware of the limitations of the social audits and code of conduct and verification as means of preventing human rights harms. There's been quite a lot of research which has given us some slightly grim findings. And so we think that over-reliance on these mechanisms could mean a step back in practices of leading companies. Unfortunately, it's the largest companies who are captured by this law who are more likely to have developed more innovative and progressive practices to manage these impacts and gone beyond social audits and code of conduct and verification. And so there's a risk that some companies will go for this low-hanging fruit, and therefore the law will perversely represent a step back from best practice. Next, civil liability. So there is a liability mechanism in here, which was frankly a pleasant surprise to see. I think that there were some concerns about whether or not that would find its way into the proposal, but it has. The liability mechanism, however, leaves something to be desired. It's simultaneously both very broad and very narrow. So it's broad in the sense that a company will be liable or may be liable if it failed to comply with the due diligence obligations, and as a result, an adverse impact that should have been identified has occurred and has caused damage. Now, there's no apparent causation or contribution requirements there, so this scope of potential liability is potentially very broad. So impacts that should have been foreseen but weren't adequately addressed through due diligence, which cause harm, could give rise to liability. However, it's also at the same time quite narrow, because it includes a sort of quasi-defense. So in cases of indirect commercial relationships, where a company has put in place contractual obligations requiring compliance with a code of conduct and has put in place procedures to monitor compliance with that obligation, it may potentially avoid liability if those actions were kind of reasonable in the circumstances. We think that this is a slightly convoluted approach to civil liability, and it may be preferable to limit liability by reference to ordinary principles of law, causation, foreseeability, remoteness, rather than have a broad approach to liability and a potentially extensive defence. And there's a resource which we've linked to in one of the slides here from us, which considers specifically civil liability in the context of mandatory human rights due diligence laws. Enforcement and oversight will be done by member state supervisory authorities, supported by a European network of supervisory authorities. Importantly, there are requirements that supervisory authorities will be adequately resourced and empowered. They'll be required to be given a range of powers, including powers to investigate, to sanction, and to hear substantiated concerns that companies are not meeting their due diligence obligations. Then lastly, the directive clarifies that directors have a responsibility for setting up due diligence processes and maintaining oversight and reporting to the board. Also, directors will be required to, as part of their directors' duties, take into account sustainability matters such as human rights, environment, and climate change when taking decisions in the best interest of the company. Lastly, directors will be required to incorporate due diligence considerations into company strategy. Now, this is one of the elements that's been, I think, most contentious in the European context, and it's most likely to be the subject of fairly aggressive lobbying. So, on to what this means for those outside of the EU. So, there are a couple of touch points which we think are worth quickly going through. So firstly, in terms of personal scope, the directive will directly apply to certain classes of non-EU companies. And the Commission's estimated that this will be around 4,000 non-EU companies in total, made up of around 2,600 large companies and 1,400 medium-sized companies. Member states are required to make sure that companies captured by the directive, including non-EU companies, have an authorised representative domiciled in one of the member states in which it operates. So in that way, it creates a kind of jurisdictional nexus. But beyond direct application, where an EU subsidiary of a third country company is covered, there's also likely to be a kind of upstream impact where the parent of that subsidiary is part of the value chain of the subsidiary. So it could potentially have more far-reaching, if indirect, consequences on corporate groups with a large presence in the EU, creating a potential shift on due diligence practices globally. Next, the scope of due diligence extends to the global value chain, meaning that companies will be required to identify and address their impacts outside of the EU. Now, the hope is that if due diligence is effectively exercised, then human rights harms could be prevented and mitigated in global value chains, improving conditions for workers and communities around the world. But there is this important restriction on the scope of due diligence in the form of this established business relationship limitation, which will place, I think, quite a lot of limitations there. And so it'll be less likely that the companies are required to undertake due diligence under the law in the first instance on their supply chains, deeper into the supply chain or deeper into the downstream. But there is one way of extending the scope of due diligence in the current proposal via a complaints mechanism. So companies are required to establish a mechanism, not a full grievance mechanism as expected by the UN Guiding Principles, aligned with the effectiveness criteria set out in the UNGPs, but a complaints mechanism accessible to a broad range of stakeholders, including non-EU stakeholders. And this complaint mechanism is linked to the identification element of due diligence, meaning that if a company receives a complaint and finds it to be well-founded, it will be considered identified for the purpose of Article 6, which concerns identification of impacts, and it will then need to be addressed by the due diligence process. Now, of course, there is a bit of discretion on companies in there, and this mechanism leaves a few things to be desired, in that there are real questions around burden sharing and whether this mechanism places an undue burden on civil society and others to monitor the activities of businesses outside of the established business relationship. But a range of parties can make complaints, again, not limited to EU stakeholders. So those are any person who is affected or has reasonable grounds to believe they may be affected by an impact. Trade unions and workers' representatives and civil society organisations are all required to be able to access these kinds of complaint mechanisms. The other issue of relevance is this substantiated concerns mechanism. So supervisory authorities that the member states are required to establish in each member state are required themselves to set up a process for any natural or legal person to submit substantiated concerns where they have reason to believe that a company is not meeting its due diligence obligations. It's then required to assess those concerns and, where appropriate, exercise their powers, including sanction, investigation, ordering cessation of infringements, or interim measures. Again, this is not limited to EU stakeholders. Next, civil liability. So the mechanism is available where an adverse impact that should have been identified through due diligence occurs and causes harm, as we noted. And given the scope of due diligence extends to global value chains, litigation could concern impacts which occur outside of the EU. Now, the directive, very importantly, is expressed to be of mandatory overriding application in cases where the law applicable is not that of an EU member state, meaning that in the case where litigation takes place in the EU for harms that occur in a third country, the directive's due diligence obligations and corresponding liability mechanism will be available and apply, even if the law of the third country where the harm occurs doesn't have equivalent due diligence obligations. So in this way, a company can still be liable for due diligence failures under the parameters of the directive. And then lastly, we've seen pushes for mandatory human rights due diligence laws in countries outside of the EU. We've seen commitments in national action plans for developing mandatory human rights due diligence in states such as Kenya. We've seen promising developments in the Latin American region with pushes for mandatory human rights due diligence laws in Colombia and Chile and Peru. There have also been proposals in Australia and Canada. And an effective EU law can serve as inspiration and a hook for advocates in those national contexts to push for their own laws. Just to note a couple of resources that might be useful for people. And again, we'll share a PDF of the slides in the chat so that people can download them. But we have a few resources that we put out recently. So firstly, how do the pieces fit in the puzzle? That's a resource which looks at the various EU regulatory measures and tries to sort of see how they fit together, essentially. Secondly, legislating for impact, which is a much more lengthy analysis of the CSDD. And then a briefing specifically on the operation of civil liability in the context of mandatory human rights due diligence laws. And then lastly, in terms of other resources, the Business and Human Rights Resource Centre operates a portal on mandatory human rights due diligence, and there's a lot of resources there if you'd like to learn more.
Thank you.
So one more thing, sorry, Elin. So next steps. So the proposal will now go through an ordinary legislative process, meaning that there'll be debate in the European Parliament and European Council, who will have to agree on a text to be decided upon. The Commissioner Reinders, who is the Commissioner for Justice and Consumer Affairs, who has custody of this file, has indicated that he expects that process to be concluded in the course of this year, with a decision to come early next year. That may be a little ambitious, but that's the timing that's been indicated. Again, the regulation is a directive, meaning that member states will need to transpose the directive into their own laws, and they'll have 2 years to do that once the directive is decided upon, with medium-sized companies to follow after another 2 years. And as I mentioned, there is feedback, an open consultation from the Commission open right now that will stay open until the end of May, the 23rd. We've got a link there which contains both the text of the proposal, but then also a link where you can give your feedback if you'd like to. So that's essentially the next steps. So, and with that, I will hand back to Elin, who will then hand over to Tabitha.
Yes, thank you very much, Gabrielle. And as we mentioned, we will share now a sort of PDF of the presentation in the chat so that you can also access all of the relevant links. So with that, I'd like to invite Tabitha to give us an overview of how the Corporate Sustainability Reporting Directive is relevant to this conversation, and how these two distinct legislative processes feed into each other. So over to you. You're muted.
Sorry, everyone. So thanks a lot, Ellen and Gabrielle, for your introduction and for your insights. It's really a pleasure to be here, and these conversations are happening at a really great time. So in this session, I will indeed be sharing with you the background of the EU Corporate Sustainability Reporting Directive, or also known as the CSRD, the impact this will have on non-EU actors, also considering that the Due Diligence Directive will also have impacts on non-EU actors, and also the importance of alignments between these various initiatives. So, yeah, thank you. The right slide. So firstly, I'll be providing some information on GRI and who we are. We're an international independent organisation providing the global common language for corporate transparency. Through a global disclosure framework, we support companies in being transparent about their sustainability performance and being accountable for their impacts on people, the planet, and the economy, which can inform decision making from the organisations themselves for more responsible behaviour. This can inform policy, for example, the results of the information disclosed can inform policy making in certain areas, and can also encourage better investment, more responsible investment from the financial markets. And the GRI standards are also the first and only global reporting standards to fully reflect due diligence expectations, so that organisations can manage their sustainability impacts, including on human rights. And how we relate to the CSRD is, I will touch on this more later in the interest of time, but we'll, along with the European Financial Reporting Group, which is known as EFRAG, GRI will be co-constructing the EU sustainability reporting standards that will be part of the CSRD. So moving on to the CSRD, providing some background, the European Commission initially launched their proposal on this in April 2021. And the need for this proposal arose from a big observation that there was insufficient information in corporate reports. So this proposal was brought forward to amend the non-financial reporting directive, which right now offers, I think it's 5 core sustainability topics that organisations should report. But again, in terms of scope of content and the scope of applicable organisations, it's much more narrow. And the CSRD proposal also aims to incorporate the expectations and principles enshrined in various international instruments, such as the UNGPs, the various OECD guidelines. And the proposal also sets out requirements for companies to report specifically to a new set of European sustainability reporting standards. Another point on this is that in July 2021 was when GRI was appointed co-constructor of the new sustainability reporting standards. If anybody needs more information on what this means, I can provide this in the Q&A. And another key component that the CSRD brings in is the concept of double materiality. Next slide, please, Gabrielle. Thank you. So this concept, which is included in the CSRD, is an extremely important recognition, because now this brings in the concept that organisations should be considering not only the impacts of their activities on their own financials and equity, but also the outward impacts that they're having, their impacts on the environment, on people, on human rights, on the economy. And that when organisations are identifying their most key impacts, they need to be considering both of these things. And now you can see on the infographic in front of you on the left, we have financial reporting, which right now is with the IFRS Foundation, who will also be established, who have recently established the International Sustainability Standards Board. In between of this, we have the European Sustainability Reporting Standards that embody double materiality, so that's both sides. And then on the right, GRI, who produces global standards, where we also focus on outward impacts. So on the next slide, please. Thank you. So the key changes that will be coming out of the CSRD, as I already mentioned, the scope. The number of companies covered will increase from around 11,700 to around approximately 50,000. So currently the NFRD, which is the current legal requirements for companies, applies to companies with more than 500 employees, including listed companies, insurance companies and banks. Whereas under the new CSRD directive, all large public interest companies and those listed on European regulated markets are required to report. And large companies are those that meet at least 2 of the following criteria, which is 250 or more employees, 40 million euros in net turnover, or 20 million euros in assets. Right now, there's big discussions, as Gabrielle mentioned already. This is a very politically charged process, both with the Due Diligence Directive and the CSRD. One key thing in particular for both being scope with the CSRD, whether or not SMEs, listed SMEs, will be included is still very much being discussed. So this is something we will be finding out at some point, roughly probably around the middle of May, which is when the EU is hoping to resume to conclude their negotiations on this. Another key component added is mandatory external audit for non-financial information. As I already mentioned, the EU sustainability reporting standards will be produced as a result of the CSRD. And also formatting requirements. The CSRD is really pushing for digitalization ensuring access and comparability of information through the establishment of a European single access point, and companies will have to digitally tag information. So on to the next slide, please. Thank you. So for those non-EU actors, in terms of how this will affect them, firstly, and this also particularly relates to the due diligence directive, there are many overlaps. In this case, those that are members of the global value and supply chains will need to provide information, even for those that are not covered directly by this directive. If they are part of the global value or supply chains of those companies who are covered by the directive, they will need to provide this information. The Commission has really pushed for information to be as robust, transparent and accurate as possible, and not to rely on average outputs. For example, to calculate the average environmental impact outputs. Instead, they ask for as much primary environmental or social data to be found from the value chain. And the source of this is suppliers. So for those suppliers of companies covered by this directive, they will be still needing to provide this information to the companies in order for the companies to meet these requirements. Furthermore, non-EU actors who are owners of EU-based subsidiaries with over 250 employees, also the owners of EU-listed companies. And another key point, which is also very politically charged and is also being discussed right now, is whether or not large companies that are providing goods or services in the EU will also be covered. Again, this is something we will find out more information on with time. But whether or not this is included will also be significant. Nobody knows the exact number, but I imagine there are a huge number of companies providing goods and services in the EU. And another way that this will be affecting non-EU actors, as with due diligence, we're seeing a huge increase in reporting provisions in general, also due diligence. And for also many actors that currently are not on the EU supply chain but wish to enter in the future, should already start looking at how these what provisions they will be subject to provide information for in the future if they wish to enter the market. So on to the next slide, please. Great, thanks. So what's next? As mentioned before, right now, the proposal is more ahead than the due diligence directive. The Parliament has expressed their positioning, which has been adopted. The EU Council has adopted their positioning. So right now, the Council and the Parliament are in their negotiation trilogues with the Commission mediating. Right now, there's no disagreement on the need for these standards or for the content or ambition. Right now, the key topics being discussed is timelines. They're expected to apply from January 2023 with the initial reports due in 2024, but it has been indicated in these trilogue negotiations that this will be extended, so would apply from January 2024 and initial reports due in 2025. Again, this is not final yet. There's also, as mentioned already, extensive negotiations on whether or not SMEs should be captured and the extent to which they should be captured, and whether or not specific standards would be drafted for them. And also there are negotiations on the assurance regime and to what extent there should be a separation between sustainability auditors and financial auditors. And from our position as GRI, what's really crucial, as Gabrielle mentioned, right now the due diligence directive is open for public consultation. At some point with the CSRD, the sustainability reporting standards will also be open for public consultation after they've gone through the European Commission internal processes. And it's crucial that people push for alignment, not only in terms of scope and topics covered, but also for terminology, classification. We know that high impact and high risk sectors is a very big topic of discussion for both these directives. These need to be classified in the same manner. And not only between the various EU initiatives, it's also critical that, for example, this same feedback is given when GRI has open consultations on their standards. The ISSB has already released their first documents for public consultation, and it's crucial that for all of these various initiatives, we push as much as possible for alignment where we can, also for guidelines, that all of these initiatives reference all of the relevant international authoritative instruments, such as UN conventions, OECD guidelines, both to relieve the reporting burden on organisations, but also to ease this for all of the policymakers and various other actors that will be affected by this. And yeah, so this was the end of my presentation. I guess we open now for questions.
Yes, many thanks. Yes, now I think we unmuted. Many thanks. That was really useful, and also showing how, you know, important it is that we look at how these different files are actually, you know, being aligned with each other, because they will have a lot of bearing, because, you know, and then there's a different scope. The standards that are being developed for reporting will somehow need to reflect what the actual due diligence obligations might be, but also we need to keep an eye on alignment with the overall principles that are within the UN guiding principles and the OECD guidelines, so that we don't sort of water down the spirit of human rights due diligence with, as many have commented, a sort of checkbox exercise where you sort of actually contract out the responsibility to other actors within the global supply chain. So there's a lot to look at. I'm aware that it's a lot of information to absorb. Nonetheless, we do have a few questions here that have been posed in the chat. And I'd like to maybe start with the question that was posed here on the supervisory mechanisms that are envisaged under the proposal. There was a question here on how the national contact point that have been established under the OECD guidelines in the OECD adhering countries and a few others could play a role. And there are actually quite a number of options considered in the proposal. So maybe, Gabrielle, if you want to answer that one. And then also, we do have 15 minutes. So for those of you who have posed questions, you can also raise your hand. We can try to bring you in if you can pose your question very quickly.
Yeah, thank you, Elin. In terms of the supervisory authority, the directive isn't particularly prescriptive about which body should be discharging the functions of the supervisory authority. Rather, it sets out that it requires member states to establish these supervisory authorities, make sure that they're adequately resourced and empowered, ensure that they have powers of investigation, of sanction, and all of the kind of various powers that I sort of mentioned earlier. It's possible that some of these functions could be farmed out to the OECD national contact point. And that's certainly been an option that's been floated by a few stakeholders, and a few have kind of raised that possibility. One of the things that's notable about the supervisory authority mechanism in the directive is that it envisages that the functions of the supervisory authority could potentially be discharged by different bodies. So some kind of bodies discharge some of the functions and some others. So there is a possibility that the NCP could have a role there. Whether or not national NCPs are kind of equipped to do so will require some additional capacity, resourcing, that sort of thing is another kind of another question, but for kind of implementation down the road. But it is possible. Yeah, certainly.
Thank you for that. Then there's a question around remedy, because we did touch briefly upon the sort of civil liability mechanism that is suggested in the proposal, but there's also an encouragement on companies to have their own grievance mechanism. So would you like to elaborate maybe a little bit on that?
Yeah, certainly. I mean, there is a requirement on companies to establish. I think it's quite important to clarify that this is a complaint mechanism that there is required to establish, not a grievance mechanism. So grievance mechanisms, operational level grievance mechanisms, as we understand them, as envisaged by the UNGPs, should comply with a number of effectiveness criteria. So be accessible and transparent, and a range of other things. What the complaints mechanism in the measure does is simply provide an avenue for affected parties, so those are those who are or believe themselves to be adversely impacted by the actions of the company, trade unions, worker representatives, and civil society organisations, empowers them to bring matters to the attention of the company, who then have a discretion as to whether or not they decide whether or not those the concerns are valid. If they make that determination, then it's then that, as I mentioned, that matter is considered to be identified for the purpose of the due diligence process, and there are a number of steps that companies need to take in order to address those impacts that they've become aware of. So there is a bit of a distinction here. So it's not as though the measure sets up a kind of an alternative dispute or grievance resolution mechanism that companies are required to establish and oversee, but rather there is this complaint mechanism, which can then feed into the due diligence process. And because the civil liability mechanism is predicated on harms which have occurred, which a company ought to have identified through the due diligence process, if a company is alerted to an issue through the complaints mechanism and considers that to be substantiated, then it's something that should that issue cause a harm later on and the company hasn't adequately addressed them, then that could potentially give rise to civil liability. So there is an interplay between the two, but they are quite distinct.
Thank you. And I see here there's a few questions. So, apologies in advance if we don't address all of them. But given also that, this webinar was supposed to look, more specifically at sort of what impact it might have outside of the EU, I'd like to pick the last question that was just put here on how this EU experience could be transferred to other regions, including in Latin America. So also, both of you, if you have any reflections or any things you're seeing, what is happening there, is this inspiring other jurisdictions outside of the EU?
Yeah, I think that's a really great question. And I think that this could potentially be a really important hook for kind of national advocacy for the introduction of due diligence laws. I mean, this EU due diligence directive hasn't come out of nowhere. It's been the subject of, I think, many years of work, and the introduction of mandatory due diligence laws in a number of the national laws of the member states themselves. So, the first mover was really France with the introduction of their duty of vigilance. I mean, there were some measures before that. The UK Modern Slavery Act is a notable one, but the French due diligence law was really the first kind of mandatory due diligence law to be in place. And you can see that the EU due diligence directive has taken a lot of inspiration from the approach of the French law. And in turn, I think that this new directive can inspire other jurisdictions to introduce kind of new or equivalent laws which sort of accord with its requirements. Having said that, you'll have noticed that I noted a couple of points of departure from the UNGPs, which we consider to be quite problematic, and a number of ambiguities with this law that I think should be resolved before those outside the EU consider adopting it wholesale. And there should be, some discretion afforded to those outside the EU to adapt it to hopefully improve it and maybe even go further than these provisions. But I think it can certainly be a source of inspiration. But I'll shut up and let Tab have a crack at the answer as well.
Thanks, Gabrielle. Yeah, I'm in complete agreement. We're already seeing, and especially I think very rapidly over the last few years as well. I know in Mexico, the due diligence bill has just been pushed through. New Zealand as well has just opened up open consultation on due diligence, which I think is also presenting a lot of opportunities. As Gabrielle said, it's really important that the due diligence directive does reflect the contents and principles of the UN guiding principles and the OECD guidelines. But these open consultations and developing policy in other countries outside of the EU is already a great opportunity to start providing feedback, start already pushing the issues with the EU directive, and also the difference in scope between the CSRD and due diligence directive can be highlighted in these public consultations. It's always an opportunity to push forward and say, okay, this isn't included in the EU, but New Zealand, for example, or Mexico can already begin going even further than the EU due diligence directive. We live in a globalized society with a global supply and value chain. At some point or another, policymakers will have to align in order to have an even level playing field for the market, you know.
Yes, absolutely. And just maybe to add here, first to answer one of the questions that came in just now in the chat, there is actually no mandatory human rights due diligence law yet in the countries that were mentioned. So here, you know, Kenya, Chile, Mexico, it is, you know, just starts of processes or commitments towards that type of legislation. What we have today is you know, the French duty of vigilance law. We also have the German supply chain law. And then there's also in Norway, this sort of corporate transparency act. And then the Netherlands also have a somehow more limited to child rights issues, human rights due diligence law. But it is emerging in many EU countries in parallel to the process that we're seeing now at the EU level. And there is, as highlighted, an opportunity also for member states, if they found the directive is maybe not going far enough, to you know, adopt legislations in their own domestic setting, which you know, require stronger due diligence from companies. Then, of course, you know, then that means that we're not addressing the issue of different types of requirements across the different countries, but that's why also the transposition will be very important. I just also wanted to mention that you know, in some of the national action plans that have been adopted relatively recently, including in Kenya and Peru, there are commitments that are written in there on developing some sort of a mandatory human rights due diligence legislation. But then, you know, somebody has to pick those commitments up and drive the advocacy so that it actually happens. But I'm happy to see that there are many of you in different corners of the world, so that's very encouraging. I think we have space for maybe one more question before we wrap up. There was one, you know, very interesting question here around, you know, how will companies actually be able to conduct human rights due diligence and respect human rights in contexts where maybe, you know, some of the key human rights are actually not respected, or where national laws are not in line with international human rights law. And there were some expressions, some examples here, you know, for example, where freedom of expression is restricted, or where there is no freedom of association as such. So maybe to both of you, any reflections? This is obviously not going to be easy on companies, but you know, they also have already committed to these principles and are already operating in some of these difficult environments. So maybe a few reflections from you before we wrap up.
Yeah, sure, Ellen. I think that it's a very good question and a very challenging one. And I think that this, you know, acknowledging that there are a number of contexts where there are restrictions on unionization or other kind of freedom of association is a good one, because I think that in there it also those sorts of contexts show the limitations of the approach that's based on contractual compliance with codes of conduct, because that in turn requires a contract counterparty in a challenging context to agree to be bound by the terms of a code of conduct, which should, in our view, mandate that the freedom of expression and association and other rights be respected. So I think that it requires a much more nuanced approach to addressing human rights harms in those complicated contexts, in contexts where there is a gulf between national laws and practices and international human rights standards, and the expectations of the UNGPs. There are a number of ways that the companies can navigate those. There's quite a good paper from the British Institute of International and Comparative Law, which looks at exactly this situation, you know, kind of how companies can navigate gulfs between national laws and international standards. It's a bit outside the scope of today's topic, but I'd encourage you to find that, and we can send that in the chat as well. But Tabitha, maybe while I'm finding that, I'll hand over to you to respond.
Yes, and if I can ask you to maybe add your sort of final reflections at the same time, Tab.
Sure, thanks. So on that question, to kind of bounce off what you said, Gabrielle, it is a very complex, nuanced issue, also not just depending on the geographical location, also depends on the sector. Many sectors operate in different ways and therefore are regulated in different ways. The opposition they may be facing can also be different. I think it's also to note that this is very much bound by what a company is capable of, proportionality. You know, what is reasonably expected of a small SME with 20 employees would be very different to the steps expected to be taken by a huge entity such as, I don't know, Unilever or Walmart, for example. So I think it's also the capabilities and the resources of the organization in question should also needs to be taken into account. This doesn't mean that exactly the same obligations will be applying if an SME isn't capable of persuading an organization to change how their actions are violating human rights and does what they can within their capabilities. Then I think that kind of would be deemed sufficient. But again, I won't be judging the outcomes of these reports, but that's my take on it. And I'd say for general takeaways, I think, as we've already said, alignment is really, really key, particularly on things like scope. As we've said, there's still a number of options for loopholes, especially on things like established business relationships. We don't want to encourage supply chain hopping. We want to ensure that both directives are also very clear in how they relate to each other. Right now, this is also quite a grey area. We don't have a lot actually on paper from the EU. And also to reflect, there's a number of opportunities to provide input in these public consultations. So at GRI, we would encourage, where possible, to provide input, highlight the shortcomings, and really, really push for alignment.
Thank you. Right, so maybe a few concluding words from you, Gabrielle?
Yeah, I think I would just echo exactly what Tabitha has just said. There are a number of opportunities for a range of stakeholders to give input into these processes. It's not always easy to find out how and where to give that input, but hopefully today's webinar has equipped you at least with like a description of a general introduction to these frameworks, and we've provided a link to the consultation in the chat. There are a number of really great, ambitious aspects of this CSDD proposal, but it could have a really seismic effect and a really positive change on how human rights are respected in global value chains. But as we've noted multiple times today, there are some really critical departures from the UN Guiding Principles and OECD guidelines, which create, I think, in an effort to transpose the soft law requirements of these frameworks into hard legal obligations, have in turn created more ambiguities. And it's quite unfortunate because we have now a decade of practice of companies applying due diligence as envisaged by the UNGPs. And what we want to make sure is that the CSDD doesn't perversely encourage a step back from those really great practices that have been developed. So we would encourage you to read through the proposal, read through the materials that we've shared, reflect yourselves as to how this proposal might affect you, and to have your voices heard and to contribute to the consultation.
Excellent. Thank you so much. And thanks to everybody for participating in the webinar. Also, just wanted to share that we hope to be able to put out a few resources also in other languages to allow people to get some analysis in other languages than English. So stay tuned. We'll try to share the recording if we're allowed to do so. We need to check with our compliance people on GDPR and the slides as well, but we'll posting it on our website. So please have a look at that regularly. Many thanks, and hope to continue this conversation in other settings. Bye-bye.
Bye. Thanks, everyone.
Bye. Thanks, everyone.